Um, Part of our kind of one of the privileges that we have here at the foundation too is that we get to talk to individuals and families about the kind of legacy that they hope to have both during their lifetime and beyond. And so one of the tools that can be part of that conversation about what kind of impact and legacy they want to leave is through a will and through estate planning and things like that. And so August is Make a Will Month, which is, one of the most exciting um, celebrations, I guess you could say, of the year. I know, but it's one of those things that when you have something like Make a Will Month, it can be a good reminder um, to think about some of these things that maybe we put off or it's always on the to-do list, but we never get to it. It can be the perfect time to think about our own plans. And we all know that life changes quickly and it's always changing, whether it's, that your family is growing or you've moved or you've retired, or maybe it's just been a long time since you've thought about your will or your estate plans. Whatever the case, we like to use this month as a time to um, kind of bring that conversation back to the forefront a little bit and provide some resources and information out to the community as well. So today we are so fortunate to have John Richter with us. He is a local attorney. He's also a Waterloo Community Foundation board member. And John is going to walk us through some of kind of the key times when it makes sense to either create a will or update a will. He'll share some simple and practical tips, whether it's something that you're starting from scratch or revisiting an existing plan. John's going to give us kind of a high level view here. So we hope that at the end of his presentation, we'll have a little bit of time for Q&A. So keep that in mind. If you have some questions come up, we'll be able to put those in the chat box, whether you want that to be public so everyone can see, or you can send them privately to me as well, and I'll ask John. I will say with a topic like this, we do want to keep things pretty general and kind of general questions that can apply more broadly, more than individual situations, because I'm sure John will say, make sure that you talk to your legal professional about that. So keep that in mind too, that there might be some more specific things that come up, and we'll hold those for a different time. But with that, I will go ahead and pass things over to our presenter today, John Richter.
Yeah, thank you, Paige. You did a great job pumping up estate planning and will making. That doesn't happen very often in the day-to-day work I do here. So that was pretty cool.
I'm for hire, John, if you want me to help do that more
we may
regularly.
need to call on you from time to time if the need arises, certainly. Okay, so I'm going to share my screen here. I've got a few slides. Can you see those okay? Perfect.
Yes, looks great.
All right. So, as Paige mentioned, my name is John Richter. I'm with the Beecher Law Firm here in Waterloo, and I've got my contact information here, and it'll be on our last slide. Again, if questions come up today, we don't get to them, or you don't feel comfortable asking them, or the question pops into your head an hour from now when you're driving to lunch or wherever it might be, feel free to shoot me an email, give me a call, or get a hold of Paige and Aaron. They know how to reach me, and I'd be happy to answer questions. But I'm a Waterloo native, was born and raised here. I went away for school, University of Iowa, for law school and for my undergrad work. And then after about a handful of years up in the Minneapolis area, practicing up there, I moved back to Waterloo in spring of 2020 and been practicing with Beecher ever since in these practice areas you see here: business, corporate, real estate, estate planning, and nonprofit. So very happy to be here today. And I know we've, as Paige said, have kind of a general broad-ranging topic that I could go on for hours about, but we'll keep it to about 20 minutes. And I do feel like this time of year is very appropriate for Make a Will Month. for whatever reason, I think it has to do with summer ending, school starting again, people sort of just dusting off their to-do lists, and they, looking at what are those things I've maybe wanted to do, or in particular with estate planning, that have lingered near the bottom of the to-do list, or low on the priority level. I think around this time of year, we start to get a lot of calls. So I'm glad we're having this discussion now, and can hopefully get some of you going in the process, or answer questions you might have as you think about whether you want to do estate planning. So with that, I mean, let's start just very generally. You hear this umbrella term, estate planning. It refers to a lot of things, and let me just take you through a little bit of what that's all about. So estate planning is simply just a set of documents, tools that are used to handle your affairs when you're living, but maybe incapacitated, or upon your death. And so, there's a couple examples on the slide here of, transferring assets, settling your debts, handling your taxes, providing for kids, pets, providing for who might be able to help you with medical decisions or financial matters when you're living but unable to handle those things. Those kind of all those things fit under the estate plan umbrella. And there are a variety of tools that are used for estate planning, some of which are listed here. The will, which we'll talk about today, all kinds of trusts and trust agreements, powers of attorney, the most typical being the medical and financial, living wills, and then beneficiary designations, PODs, TODs. Those are kind of the most common tools you will come across probably in just day-to-day estate planning. But again, this is an overarching term, and today we're going to focus a little bit on the will, which is simply one of those tools that is used to handle some things upon your passing. So we talked a bit ago, you can have tools that go towards when you're living, maybe when you're incapacitated, or when you're passed. A will is put together while you're living, but takes effect when you pass away. For most clients that I work with, the will is sort of the backbone of the plan we put together. It's simple, straightforward in most cases. It's an efficient way of handling your affairs, but it's very effective. Among other things, it handles most commonly distributing property, to your loved ones, to your friends, to whomever, the assets you own, specifying where they're going. Names an executor, which is just the legal term for the person that has the authority to carry out the terms of your will and make sure, property is distributed. The other terms of your will are followed. It can handle, the guardian of your minor children if you have them. And it can handle a variety of other objectives, details, meet goals. I've listed here, sometimes we have funeral, burial, cremation wishes listed. Charitable giving is a big one that goes into wills or in other planning documents. But a will can achieve all those things. And again, it's usually in a very simple and efficient manner. A will, I often get the question like, well, okay, so a will handles my property transfer, does that mean all my property? And the short answer is typically no. So a will really sort of sits as a backstop, or kind of sits in the background to handle property that does not transfer by operation of law. So what do I mean by that? Two most common examples are jointly owned property, or property that has beneficiary designations. So jointly owned property, think of a married couple, maybe they have one or more bank accounts that they're joint owners on, or real estate, whether it's their personal residence or other real estate they own. They're titled jointly with rights of survivorship and not as tenants in common. Those types of properties, those examples, will, when one spouse passes away in that example, the surviving spouse will automatically have ownership to the entire asset vest in them. So the will does nothing to change how that works by operation of law. The bank account, the real estate, whatever it might be, simply transfers upon one person's passing, and we have to do no more to handle that asset and getting it to the surviving spouse. Similarly, beneficiary designated assets, think of life insurance policies, think of retirement accounts like a 401k you might sign up for when you start a job. When you sign up for those things, the life insurance company, your employer, they might give you a beneficiary form. They should give you a beneficiary form where you can fill out primary beneficiaries, who you want to receive those assets when you're gone, maybe secondary beneficiaries as a backup to your primary if your primary beneficiaries are gone before you. But again, when you pass away, if you own those assets, those beneficiary designations control where those assets are going. The will does not change that. So again, think of a will as kind of our backstop. Property that's left over that doesn't transfer by operation of law will get swallowed up by the will, and then the will specify how your property transfers from there. So just a couple, I think, I don't know if they're misconceptions, but more so questions about those types of property. They come up all the time, and I thought I'd just go over that briefly for you guys here. So now that we've talked a little bit about what a will is, what it handles, who needs a will? Again, common question I get here in my day job. I might be biased, but I would say probably everyone could benefit from a will. Not just those that are perceived as having high net worth or wealthy. But if you think about it, we all have loved ones, whether they're family, friends, charitable causes we're passionate about. We all have property to our name, right? Whether it's a home, whether it's furnishings within the place you live, a vehicle, whatever it might be. The will allows you to provide for those things and those people you care about when you're gone. So, as I mentioned, property can be delineated to specific people within the will the way you want it to, transfer or be distributed. Versus without a will, you're going to just be left to the default provisions in the Iowa Code that say how property transfers if you do not have a will. Further, reducing these things to writing, of course, then provides some clarity for your loved ones, for whoever might, be handling your estate, your affairs when you're gone. Of course, having things in writing, signed, witnessed, done with an attorney's office usually provides a level of clarity, and then in turn helps avoid disputes over property or guardianship or whatever it might be when you're gone. And the will goes a long way to providing that clarity. In addition, a will plus having communication or conversations with your loved ones about the planning you've done goes even further to kind of setting people down the same path and hopefully avoiding disputes down the road. I can't tell you how many examples of client conversations I had where they said, yeah, everyone felt really good after I set up my will, but they felt even better when I kind of walked through with them what that meant and what I put in writing. The conversations amongst loved ones often goes along a lot farther than a loved one picking up a packet of documents from my office and trying to sort through them themselves. So keep that in mind too. If you do a will, the conversations go a long way. The will also, of course, preserves assets if you so choose, for loved ones that maybe have special needs, or maybe they're a minor. For example, a will could provide for a trust that goes into effect when you pass away, that a share of your property goes into that trust for, let's say, the 12-year-old child who stands to inherit from you, but maybe shouldn't be, or you don't want them to be inheriting property, such as that sort of trust that we can put in place in a will to preserve those assets for those loved ones. And then I'll just mention a couple quick hitters. If sometimes we have clients where spouse isn't comfortable with financial matters, or clients own a business. I mentioned children, special needs cases. All those situations can be wrapped up into estate planning with a will, and often are handled that way. So hopefully, after today's presentation, if you've been on the fence, you'll say, okay, I want to make a will, but you might be wondering, how do I do that? And what does the process look like? So I'll speak today a little bit just about the process I go through, which I think is fairly representative of the process you'd go through with other attorneys in this community, certainly. It usually just starts though with us getting you a questionnaire where we can start gathering personal information, about you, your spouse if you have one, kids, grandkids, other loved ones, and then also about the types of property, the types of assets you own, as well as any debts that maybe go with those assets. That allows us to, well, that combined with kind of the third bullet point here, reviewing, certain types of your assets, those retirement accounts, those life insurance policies, those bank accounts, those items that I talked about earlier that might have joint ownership, beneficiary designations. We would like to review those in conjunction with that questionnaire you fill out to make sure you have all those set up properly so that those assets flow outside of the will when you're gone and don't require an attorney's involvement or other folks' involvement to transfer those assets. But all of those things, those first three bullet points in particular, going through that process really allows us to give you personalized recommendations and to set up, personalized documents for you. As I mentioned, the will can be very straightforward, simple, a couple pages in length, but it can pack a lot of punch. It can have a lot of specific terms that work for you, but that maybe don't work for someone else. So going through this process is very important from my perspective to making sure we get you a proper plan in place. So, once we've done that, we'll draft your documents. We'll get you in. You'll sign your documents with 2 witnesses. Here in Iowa, you need 2 witnesses to make a valid will. But before we do that, before we do the signing, we'll often talk to your professional advisors if it makes sense. So CPAs, financial advisors, bankers, insurance agents. If we have questions about taxes, if we have questions about a business, about your specific life insurance policies, whatever it might be, I always like to get the other experts in the room or on the phone, work through those items so that there are no surprises, right? If I'm doing an estate plan and that estate plan gets handed to an advisor or conveyed to an advisor, we don't want any surprises. We want them to be on board with what we're doing. So often before we get you in to do that signing, we'll have those conversations just to dial in those documents, and then we'll finish everything up. And I'd like to think, and I think this holds true, again, around the community, that you'll find the will making, the basic estate planning process to be fairly efficient, straightforward, and not requiring too much of your time to invest to do it, and then also at a reasonable cost. We like to, make this process easy for people, not burden them with a huge bill, because we also like to develop the relationship right at the front end. This is often the first touch point that people have with an attorney ever, unless they have some other, business or whatever it might be going on in their life where they've had occasion to call an attorney. Estate planning is often the first time they get involved with one. And the nice thing about having a good, pleasant experience on the front end is they feel like they can trust you and they can call you in the future with any additional questions, concerns, legal matters. So for that reason, I like to keep the estate planning process simple, easy for you guys. So part of today's topic would be, okay, you've done the will, or maybe you've had one in place for a long time. When then do I need to go through updates, or when should I be thinking about them? I've listed here a handful of types of events or things that should prompt you to maybe pick up the phone, call your attorney, or at least think through it on your own and pick up your own documents and look at them. These sort of apply to anyone and everyone. So, the first set of items would be occurrence of significant life events. Think of this as marriage, divorce, birth or adoption of children or grandchildren. Someone passes away that's near and dear to you, that's maybe named in your will. You move to a new state. All those instances are definitely reasons to dust off your documents, take a look at them, see what they say if you need to refresh your memory. And then probably pick up the phone to call your attorney. Just have even a 5-minute conversation about, hey, this happened in my life. What do you think of my estate planning documents, and how does that affect them? And similarly, financial changes. Think of inheriting property, acquiring new property. Maybe it's a second home, or you have a business and it starts to take off, or you're looking to sell, or you have sold. Again, all things that would probably affect your planning, and good reason to pick up the phone to call your attorney to go through the updated estate planning process. And then similarly, these last couple items, we often see, as attorneys, of course, changes in laws. By way of example, well, certainly since I've been alive, there have been all kinds of federal estate tax law changes over the years, and they kind of, you see them sort of swing back and forth with new administrations, the presidency, with the makeup of Congress changing. It's the nature of the beast. And in addition, at the state level, currently Iowa is phasing out its inheritance tax law, so that'll be going away. So anytime we have a change like those, it's a good reason to maybe look at your planning, and potentially update it. In particular, if you have done planning, and let's say it's 20 years ago when there was a new tax law that was, the latest and greatest, but that caused maybe some people to do heavy tax planning because of it. Well, I mean, 20 years ago is a long time, and laws have certainly changed since then. It's probably good reason to get in and at least have that conversation to see, if you need to work with your attorney to do some updating. And then lastly, or second to last rather, change in relationships. Touch on this a little bit with, marriage, forced birth, death. But things happen in life. Falling out with a friend, a family member, a beneficiary in your will, or someone that's named to handle your affairs. That's a perfect example of when you should pick up the phone to at least just do a simple update to swap names, or get someone new put in place. That happens all the time, unfortunately, but good reason to keep it in your back of your mind as it relates to estate planning as well. And then last, just by best practice, I tell people, whether it's a year, every 2 years, 5 years, whatever you feel comfortable with, just sort of maybe put a reminder on your own calendar, maybe around tax time, or maybe when you have some free time at a certain point in the year, to just pick up your documents, think about whether these life events have happened, and then maybe give your attorney a call to see if you need to make any updates. And then, of course, I think the last thing I'll leave you with that can hopefully come in handy, you start thinking about making a will, or you have a will, you start thinking about doing those updates, and you wonder, well, how do I go about doing them? I've, made reference a bunch of times today about picking up the phone to call your attorney. But if you don't have one, or you're maybe looking for a new attorney, here's a few tips. So there's plenty of local estate planning estate planning attorneys, here in Waterloo, Cedar Falls, maybe some turkeys too. But lots of good options here, and tons of clients of mine have come through referrals or just personal contacts, right? Where, hey, my neighbor used you, or hey, my dad did his estate planning with you, or whatever the connection might be. Word of mouth and trusted relationships go a long way in a community of this size, and so we rely on that quite a bit here as attorneys. But I think as potential clients too, potential estate planning folks, you'll find that your network probably has good referrals for you too. But if you don't have a good referral, or someone that can point you in the right direction, we have our local lawyers association, the Blackhawk County Bar Association, the Iowa State Bar Association at the state level, or organizations like Legal Match, who are paid to kind of match people with attorneys. They all can point you in the right direction if you need a referral. And then similarly, your own contacts already in the professional world. So whether it's your CPA that does your taxes, your insurance agent, your financial planner, your banker, they all work with attorneys on a daily basis, and it goes for me too. I work with those folks all the time, and so if you need a referral one way or another, you could call them up and I'm sure they could give you at least one, two, or if not a handful of names to call. And then last, I'd probably be remiss if I didn't mention, in today's age, the online options that are available. So you see advertisements for like LegalZoom, Rocket Lawyer, similar agencies that provide legal services just really over the internet on a virtual basis. That can be a really handy, efficient, cost-effective way to do this type of work. However, of course, it comes with some drawbacks. I think, you don't have necessarily the person that you can go visit or even kind of pick up the phone at the drop of a hat to give a call, to like you would someone in the community. And they're usually more nation or worldwide based organizations to where, they have expertise in people that specialize in, say, Iowa law, with what we're dealing with here, but maybe they're not keeping their ear to the ground the same way someone local would be, or maybe they don't know the developments in your community that would affect your plan, or the developments in the state just on an economic or legislative level, whatever it might be. And then lastly, they also really don't have much of an incentive to follow up with you. So when you conclude the process, often you get your packet of documents and your bill and you move on. Whereas hopefully, with someone like myself or another attorney in the area, we would bump into you at a local coffee shop or restaurant, or maybe we're friends and can have touch points that way. And just continue to build the relationship. So if you need an attorney down the road, you can give us a call. So hopefully that didn't sound too much like, legal services marketing, but I really just wanted to provide you with some options on where to go if you want to get this process going or to do those updates. And with that, I'll conclude with giving you my contact information here, and then maybe after a minute or so, I'll pull this down so that if there are any questions, we can go over those.
Yeah, that's great, John. Thank you so much for all that information. Make it seem much more, approachable, something that we maybe put off or don't want to do because we don't know where to start. I think your information helped kind of demystify some of that process of who do I call and what are they going to ask me and all of that. We have had a couple of questions come in here, and for one of them, it sounds like some will documentation has been sent to them from a organization, and if somebody has some of those pieces in place, can they bring it to a lawyer to have it witnessed and made official, or do you really need to start from scratch with the attorney? How does it work when someone maybe has some of those pieces in place from another organization?
Yeah, so if I'm understanding the question correctly, I think, maybe there's a document that has not been signed or has been signed by the person making the will, but it has not been witnessed. If it's been signed, or if it's going to be signed, it would need to be signed in front of those two witnesses. And doesn't mean that that person necessarily needs to start from scratch. If the work's been done, and I would, if it came to me, if this document came to me, I would often probably just give it a look, offer any recommendations I see. But if it works, if it does the trick for that person, we don't necessarily need to start from scratch. We could, probably take that document, put it on new paper, right? Update the dates, sign it with witnesses involved so that it is valid in the state of Iowa. Hopefully that kind of speaks to that question.
Yeah, I think so. I think that addresses kind of the part of it. Another question tonight is about what the average cost locally is for making a will with an attorney. And I know you can't speak for others or be too specific because it depends on people's situation, but do you have kind of a ballpark? Are we talking hundreds or thousands or millions, or what can you give us kind of a range ballpark for what this would cost?
Yeah, absolutely. I think, for a run-of-the-mill estate planning exercise where you're doing like a last will and testament, and then typically with that, we recommend financial and medical power of attorney documents for when you're living. And of course, that's probably another topic for another day, maybe next year, I don't know.
September is actually the month for that.
Yeah, well, there you go. Maybe in September we can cover that. But with a basic package like that, I'll tell you, what I charge and what a lot of attorneys here at our office charge as a baseline fee would be $275 for a single person or $350 for a married couple. There's some give or take there, of course, if there's more complexity or if it's a different firm, the fee structure will probably be different. But I think that can give you, again, a baseline idea of what fees might be. And then I think within the community, you'd find some similar quotes within that ballpark. Again, there'll be some exercises that get more costly because they're more complex or just take more effort and time. But hopefully that gives you a good range.
Yeah, no, I think that's helpful to just kind of frame up that conversation a little bit. No, that's great. John, thank you. Thank you so much for your time and your expertise today. We did not pay him $275 to be here, so we are grateful for your time and sharing this with us. And thank you to everyone for attending too. I will say too, John mentioned charitable giving throughout this conversation a couple of different times. And as you start to think about your estate planning and that kind of thing, if the Waterloo Community Foundation can ever be helpful in that aspect, if you're wanting to do some charitable giving or just want to know what that can look like, as we're always here for that conversation. We want to help support you and give you the right resources. And that's not necessarily you're signing on a dotted line with us, and that's not pressure at all, but we want to be here as a resource for our community if you want to be generous in that way. And so thank you all for being here. We've recorded the session. We'll be sending that out soon if you'd like to revisit anything or share with others, but appreciate you all spending part of your lunchtime with us today. Enjoy the rest of your Thursday.